Great. Good afternoon, everyone. I'd like to call this meeting of the COVID-19 Task Force to order. My name is Jay Corpening. I serve as co-chair of the task force along with Senior Resident Superior Court Judge Don Bridges. At the outset, I would like to remind everyone that this meeting is subject to the North Carolina open meeting laws and is being live streamed to allow access by both the public and the media. I'll ask you during the meeting if you need to ask a question or make a comment that you identify yourselves so that everyone else participating in the hearing and those that are joining us via live stream will be able to determine who's talking. So with that, I'll ask Emily to do a roll call, please, of members present.
Judge Bridges.
Present.
Judge Corpening, you're here. Judge Vincent.
Present.
District Attorney West.
Present.
District Attorney Evans.
Here.
Clerk Chingary. I'll come back to her. Kinsley Craig. I'm here. Kelly Myers. Kelly, are you here? I thought I saw you join. Kelly, can you hear us? You're not on mute. There we go. Yes.
Okay. Yep.
Jennifer Harjo.
Present.
Mr. McCabe.
Present.
Mr. Harrison.
Here.
Mr. Keister.
Present.
Judge Sermons. Judge Sermons, are you with us yet? I don't see him on the list yet. Clerk Chingary, have you joined us? Okay, so Judge Corpening, it looks like we're missing Clerk Chingary and Judge Sermons, and we received prior communication that Magistrate Cheek, Attorney Weed, and Clerk Johnson would be unable to attend. So we're currently missing 5 members. And just for Danielle's sake, for the notes, that is Clerk Chingary, Magistrate Cheek, Clerk Johnson, Mr. Weed, and Judge Sermons. I will keep an eye out for Judge Sermons and Clerk Chingary and send you a note, Danielle, if I see them join.
Good afternoon. This is Elisa Chingary. I've joined. Thank you.
Hello, Clerk Chingary.
Hello.
Just Judge Sermons that we're expecting.
All right. Thank you, Emily. This is Jay Corpening again. I'd like to move to approval of the meeting of our June 11, 2020 task force. Minutes were submitted to all of you electronically by Danielle Carmen. Any additions or corrections to the minutes from our June 11, 2020 meeting? Hearing none, is someone willing to make a motion to approve the minutes from June 11?
Judge Corpening, this is Teresa Vincent. I make a motion that we adopt the minutes from the previous meeting, June 11, 2020.
Thank you, Judge Vincent. Motion's been made to approve the minutes by Judge Vincent. Is there a second?
Good afternoon. This is Elisa Chingary. I second.
All right, motion's been seconded by Clerk Chingary. Any discussion? Hearing none, Emily, I'll ask you to do a roll call vote for approval of the minutes.
Judge Bridges.
I vote yes.
Judge Corpening.
Yes.
Judge Vincent.
Yes.
District Attorney West.
Yes.
District Attorney Evans.
Yes.
Clerk Chingary.
Yes.
Kinsley Craig. Yes. Kelly Myers. Kelly, can you hear us? Kelly, I'll come back to you. Jennifer Harjo,
Yes.
Mr. McCabe? Mr. McCabe?
Yes.
Mr. Harrison?
Yes.
Mr. Keister?
Approved. Yes.
Kelly, can you hear us now? She said she's going to try to call in. She voted yes via the chat. And Judge Shermans has not joined us yet. So that is everyone.
All right. Thank you. This is Jay Corpening again. The minutes of the June 11 meeting are approved. Turning now to final approval of recommendations for resumption of jury trials. I recognize Judge Bridges.
Thank you, Judge Corpening. All of you will recall that at our last meeting 2 weeks ago, we covered the substance of what we hoped would be the final draft of our plan for the resumption of jury trials. At that meeting, we addressed certain points. By now, you should have before you an actual printout of the present draft of that plan for the resumption of jury trials. I do not expect that anyone would be surprised by any provision that currently appears in that plan, and if you are surprised by any aspect of it, please feel free to speak up and let me know as we go along so that we can try and address those concerns. Basically, what you will find as the difference between today's draft and the draft we were working from 2 weeks ago would be a total of about 4 points. The first of those is, as we mentioned at the last meeting, we decided to incorporate in this plan provisions for input by the Chief District Court Judge and indeed the possibility of drafting of a separate plan that would apply to the district court in each respective district. As we all know, there are indeed jury trials conducted in the district court as well as the Superior Court. So we have provided some amendments, and I would welcome any comments from Judge Corpening that he may wish to make in this regard, because he has provided some suggested language for incorporation of the district court provisions in the current version of the plan. But I will point out one notable aspect of the current draft, and that is, in this version of the draft, it is intended to be flexible in the sense that we will leave it in the form of a local option with the Chief District Court Judge, in effect, either to be involved in the process whereby the plan for jury trials in the Superior Court is adopted, and after being involved in that process, the Chief District Court Judge could, at his or her election, choose to have the district court plan covered by that same plan. In other words, a comprehensive plan for both the district court and the Superior Court divisions within that judicial district. Or in the alternative, the Chief District Court Judge has the flexibility to submit his or her own separate plan that would apply to district court jury trials within that district. So we've tried not to dictate necessarily exactly how that's done on a local basis. But the plans attempt to mirror each other to a large extent. So that is one difference between today and the time we last spoke. The second difference is, as you all will recall, District Attorneys Mr. West and Mr. Evans made a request at the time of our vote upon approval or rejection of this plan that if they could incorporate a footnote expressing concerns that they had with some of the language that was being used, they would be willing to change their votes as being opposed to the plan to votes being in favor of the plan. We have now incorporated into the current version of the plan language in a footnote that I believe is consistent with the minutes from our past meeting. And that is included in the document that's been provided to you, spelling out the concerns that were expressed by Mr. Evans and Mr. West. A third point, and now this is one that we did not specifically talk about, but since the time of the last meeting, we have been provided with a national public opinion poll that gives us an indication of some of the citizen concerns that are associated with being called for jury duty during the time of continuing threats by COVID-19. And you now see that poll on your screen. It has been suggested that that poll could be a helpful appendix to our report simply for informational purposes. And you'll see that on page 6 of the report, we make reference to that as Appendix C. Then the fourth, one other point that I failed to mention, and then going back to point number 2, with respect to the request of the district attorneys West and Evans, not only did we add a footnote, but actually pursuant to a request that was submitted by them shortly before our meeting 2 weeks ago, they had included additional language that they were requesting be included under the caption of stakeholder concerns. And as you all will recall, our section on stakeholder concerns has been something that we have basically tried to honor any specific requests that were made by the various particular stakeholders that were represented among this task force. So at the request of Mr. Evans and Mr. West, we have now included in this draft on page 5 of this report that additional language under stakeholder concerns. The fourth and final point is that even though it appears as a separate section of this report that is best safety practices for jury management and for jury trials that has been submitted to us by the Best Safety Practices Working Group, we have made reference during in this section on our plan for the resumption of jury trials to those best safety practices, and in effect tried to incorporate by reference those various best safety practices. So in a sense, even though that is listed as a separate item on today's agenda and will be considered shortly, that is in effect also a portion of this plan for the resumption of jury trials. So with that, I will ask, are there any questions from any member of the task force concerning our current draft as to the plan for the resumption of jury trials?
Ms. Bridges, this is Teresa Vincent. I don't have a question, but I would like to thank you all for taking into consideration my comments and requests as it relates to Chief District Court judges. I really like the option of being able to collaborate and go with the plan of Superior Court judge, and if that doesn't work, having the ability to do something independently. And so I'm pleased with the recommendation. Thank you very much.
Thank you, Judge Vincent. And frankly, I appreciate your pointing that out to us at a previous meeting. That was certainly not intended as an oversight, but thank you for making sure that we included that. Are there other questions or comments about the plan as it is currently drafted?
Judge Bridges, this is Jay Corpening. I think there was one other sentence that was added in paragraph 1 of the task force recommendations, some language that came from the Technology and Innovation Committee.
That is correct. And that was from through their recommendation.
I've got it. I can go ahead and read it. In paragraph 1, Technology and Innovation Committee recommended adding the phrase, based on the rule of law, the fundamental constitutional and statutory rights afforded to criminal defendants and victims, and then it goes on to talk about the discretion of the Chief Justice. That's on page 7 of the draft report.
Yes. Thank you, Judge Corpening. That is indeed an addition. I appreciate you pointing that out. Are there any other questions or comments to the plan as currently drafted? Do we have a motion then that this plan in its current form be approved by this task force as being our final draft of our plan for the resumption of jury trials in the courts of North Carolina?
This is Wade Harrison. I would move that the plan as it is presently constituted be adopted as our recommendation.
Thank you, Mr. Harrison. Is there a second to that motion?
Teresa Vincent, I second that motion.
Thank you, Judge Vincent. Is there any further discussion? Emily, would you please take a roll call vote on the motion to approve this plan as our final draft of a plan for the resumption of jury trials in North Carolina?
Judge Bridges,
I vote yes.
Judge Corpening,
I vote yes.
I saw Judge Sermons has joined us. Judge Sermons,
How about yes?
Judge Vincent,
Yes.
District Attorney West,
Yes.
District Attorney Evans,
Yes.
Clerk Shingari,
I vote yes.
Kinsley Craig,
I voted yes.
Kelly Myers. Can you hear us now, Kelly?
Yes, can you hear me?
Yes, we can hear you.
Great, I vote yes.
Jennifer Harjo,
I vote yes.
Mr. McCabe,
Yes.
Mr. Harrison, Mr. Harrison, can you hear us?
Yes, I vote yes, I can hear you, and yes, I vote yes.
And Mr. Keister.
Yes.
That's all who is present.
All right. Thank you very much. That will conclude my presentation as to item 3 on the agenda.
Thank you, Judge Bridges. This is Jay Corpening again. And Judge Bridges, thank you for your leadership on that very challenging issue. All of us are grateful to you for that leadership. Moving to number 4 on the agenda, approval of recommended best safety practices for jury trial. I'll recognize Kelly Myers for a presentation on the final report from her committee. Just for your reference, if you have the report before you, the report of her committee is set out on pages 12 through 19 of our draft task force report. Kelly, with that, floor is yours.
Thank you, Judge Corpening. Can you all hear me?
Kelly.
Okay, great. So what we submitted is essentially the same information and recommendations that we submitted several weeks ago, with the addition now of sources. So we cited sources to various recommendations of public health as was requested, and we inserted those sources throughout the text as we did in the first set of safety recommendations, rather than as an appendix, just for consistency's sake. And then there were, I think, one additional thought that has been added regarding face masks for jury members and for witnesses, which is the DHHS, actually our intern from DHHS, Nyla, suggested the face masks with a clear window that are used by individuals who are deaf and hard of hearing to facilitate lip reading and to be able to see someone's mouth and somewhat facial expression. So we included that and included a link to what those look like and how you can even make one of those at home, if that's a consideration that people may want to make. And then also included some additional links, which I believe Danielle included as a footnote. Trying to find which page that was on, but there was a footnote of just some additional resources that were used. It's at the bottom of page 12. So those, I think that highlights all the changes, unless someone has anything else to say or ask about them.
Thank you, Kelly. This is Jay Corpening again. Thank you for your leadership on this committee, and to the members of your committee for your hard work. Any questions or comments for Kelly about the final report from her committee? Hearing none, is someone willing to make a motion to approve the final report of the recommended best safety practices for jury trials submitted by Kelly Myers Committee?
Judge, this is Jennifer Herjo. Could I ask a question before we move on? I'm sorry. I was
You
a
certainly can.
little slow about the comments. So I know that in the report that we just voted on, that discusses that we are considering the defendant's constitutional rights and the rule of law in regard to proceeding. And I just want to make clear that we have those same provisions in regard to safety practices with jury trials. And if, I guess that my thought is, since that comment is already contained in the report, I'm not necessarily certain that it needs to be contained again within the jury trial section, but I guess I just also want to make clear that it is applicable.
And I think we included the language, well, we kept in the language that was approved last time on the third paragraph on page 15. It says, when considering whether individuals should be required to wear masks or face coverings in criminal trials, the rights of the defendant should be weighed against the health and safety of all individuals in the courtroom. That was the language that we took from the federal court's jury trial document.
Okay. And I'm sorry, I'm looking at it and the print's small. This is Jennifer Herjo again. I guess I just did not see that or overlooked that. So I'm okay. That's fine.
Thank you for your question. Better to have questions asked or comments on the report from Kelly Myers Committee.
Judge Corpening, this is Elisa Chin Gary. I just wanted to make a comment for the record or food for thought. On page 4, where it talks about a prolonged period of time and that it is that health professionals are unable to dictate a specific time that people may assemble in the same room safely. Our local health professionals have encouraged either judges take routine breaks during the course of a session, or that our clerks be rotated so that they are not in the courtroom for more than a half day. So while generally there may not be a determination of a specific time, in order to reduce risk, there has been some science of taking breaks does help to mitigate any risk factors.
Thank you, Clerk Changary. This is Jay Corpening again. Any other questions or comments? Right, hearing none, is someone willing to make a motion to approve the report from Kelly Myers Committee on Best Safety Practices for Jury Trials?
Judge Corbin, this is Waylon Sermons. I so move.
Thank you, Judge Sermons. Is there a second?
Judge J.D. Keister, I second that motion.
Thank you, Mr. Keister. Motion's been made and seconded. Any discussion on the motion? Hearing none, I'll ask Emily to do a roll call vote on approval of the motion.
Judge Bridges,
I vote yes.
Judge Corpening,
I vote yes.
Judge Sermons,
Yes.
Judge Vincent,
I vote yes.
District Attorney West,
Yes.
District Attorney Evans,
Yes.
Clerk Chingary,
Yes.
Kinsley Craig,
I vote yes.
Kelly Myers,
Yes.
Jennifer Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison,
Yes.
and Mr. Keister.
Yes.
That is everyone, Judge Corpening.
Right. Thank you. This is Jay Corpening. The motion passes. The report's approved. Thank you again, Kelly, for your leadership on that issue. Moving now to approval of the Technology Innovations long-term recommendations. I'm not sure that I've seen Judge Henry on the call. Judge Henry, are you with us today?
Corpening, he emailed me and let me know he would be unable to attend due to court.
All right. Thank you. Someone else from the committee like to summarize that report? It is set out on pages 19 through 24 of the draft final report for our task force. Anyone else from the committee? Mr. Harrison, perhaps you'd like to comment?
Just briefly, most everything that we've done in that part of the report just carries forward ideas that we've made in our interim report. Probably the most valuable thing we did was add some resources for the administrative office of the court to use to investigate and perhaps develop projects that will take some longer term investment of time and resources. And those include remote dispute resolution for certain simple items, and triage procedures to try to streamline processes for particular cases to save time. And then we in response to the Chief Justice's request, we set out separately any any recommendations that we had that would require legislative action, and the only one was the amendment to the rules of civil procedure to expand the court's authority under Rule 53. And we've talked about that before here at the task force level. So that's really all, pretty much all there is. Nothing radical or surprising.
Thank you, Mr. Harrison. And while you're speaking about the committee, would you mention the Appendix E item, the article from Alaska that was published in the Law Review?
Yes, sir. This is Wade Harrison again. We've had a great deal of support from the National Center for State Courts, in particular in looking at things like triage and remote dispute resolution. This article is one of the few that discusses an ongoing program that may work for us. Unfortunately, it was not accessible via the internet because it was behind a paywall. So our contact at the National Center for State Courts was kind enough to put us in touch with the author of the article, and the author agreed that we could include it in this report. And it's included as a part of the report because it's not possible for us to just to create a link to it within the report as we did for most of the other resources.
Thank you, Mr. Harrison. This is Jay Corpening again. Any questions or comments about the Technology and Innovations report? All right, hearing none, is someone willing to make a motion to approve the final report from the Technology and Innovations Committee?
This is Wade Harrison. I so move.
Motion has been made by Mr. Harrison. Is there a second?
Robert Evans, I second.
Motion seconded by Mr. Evans. Any discussion on the motion? Hearing none, I'll ask Emily for a roll call vote for approval of the motion to approve the Technology Innovations Committee report.
Judge Bridges,
I vote yes.
Judge Corpening,
I vote yes.
Judge Sermons,
Yes.
Judge Vincent,
I vote yes.
District Attorney West,
Yes.
District Attorney Evans,
Yes.
Clerk Shingari,
Vote yes.
Kinsley Craig,
Yes.
Kelly Myers. Kelly,
Yes. Yep.
Jennifer Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison,
Yes.
and Mr. Keister.
Yes.
That is everyone.
Thank you, Emily. This is Jay Corpening again. The motion carries. Thanks to Judge Chuck Henry for his leadership, and to the members of the committee who worked tirelessly to try to produce this product for the Chief Justice and for all of us. Thank you so much for your work. Next item on the agenda is discussion of recommended statutory or rule changes and funding concerns. We've had this item on several agendas and have never spent any length of time discussing it, but there have been some limited statutory or rule changes that have been recommended by our Technology and Innovation Committee. We've had some discussion that perhaps this could be deleted from our report as a separate standing item. We have shared with the task force the Administrative Office of the Court's budget request. AOC has already made those requests, and and has done the work on those budget requests. At this time, I'm inclined to delete it from the agenda. Judge Bridges, thoughts about that?
I agree with Judge Corpening on those points.
Judge Corpening, this is Judge Sermons. I know Andrew Simpson is maybe monitoring the call. I was wondering if Andrew would weigh in on where we are with the legislature. Are they going home in 2 days, and would anything we did have any effect anyway? Or, I mean, I tend to agree with you gentlemen that it'd be delayed, but just didn't know if Andrew needed us to do anything before they left town.
Judge Shermans, I don't believe that Andrew is on the call today.
Okay. How about you, Anna? Do you know of anything?
I don't believe Anna's on the call either.
Who's this? I'm sorry. I agree that it should be deleted then.
All right, then the co-chairs are going to delete this item from the agenda. Moving to final approval of the draft second report to the Chief Justice.
May I ask, this is Wade Harrison. I'm sorry, may I ask one question?
Yes, sir, Mr. Harrison.
The only, to the best of my knowledge, the only statutory change that was requested, other than the budget items, was the proposal to amend Rule 53. And I would like to see that stay in the report simply because it might provide a broader base of support for that. That idea came out of discussion in the Technology and Innovation Committee and had support by both district and superior court judges who expressed the opinion that Rule 53 reference was often ignored and seldom used, but could really facilitate the administration of justice and could get some of this stuff out of court during this COVID crisis. The amendment itself pertains only to family law matters and would give district court judges the authority to refer custody, child support, alimony, and equitable distribution cases to a referee arbitrator. And this is specifically designed for these complicated cases that take weeks at a time.
Mr. Harrison?
Yeah.
I just wanted to clarify. I don't think anyone was suggesting taking that out. I think that the judges were just referring to not having a freestanding section that is highlighted at the end of the current draft.
That's fine. I'm sorry, I misunderstood.
That's okay. I just wanted to make sure I think that's what you all meant.
Yes, thank you, Danielle. This is Jay Corpening, and maybe I didn't express myself clearly. That provision is already approved by the task force for inclusion in the report. We just felt like there was not a need for a separate section on statutory or rule changes or on budget items. But yes, that's already approved.
Okay, thank you, and I'm sorry to have wasted everyone's time.
Mr. Harrison, always glad to hear from you. Thank you. So moving on to the final approval of the report, we have approved several sections of the report today. There are a few edits that have been made that that I need to point out for the task force, and then I'll ask for a motion to approve. On page 2 in the table of contents, we refer to several appendices. One is the National Center for State Courts COVID poll PowerPoint that was referenced in earlier discussion relating to presumption of jury trials. That's proposed to be included as Appendix C. And then Appendix E, the article that Mr. Harrison was just discussing, an article written by Stacy Mars entitled Faster and as Satisfying an Evaluation of Alaska's Early Resolution Triage Program, published in the Family Court Review, October 23rd, 2019. There is, on page 3, based on our conversation that we just had about not having a separate section on statutory or rule changes, as well as funding concerns, and deleting that from the agenda, item number 4 in the introduction would be deleted. Judge Bridges has already addressed the stakeholder concerns submitted by the district attorneys set forth on page 5, paragraph 3. We have not approved that section of the report yet, so that's an update that we'll need to include in approving the final report. We have tried to be as inclusive as we can be for all the stakeholder groups that have been involved in this process, so that their very legitimate concerns are clear, and the Chief Justice has access to all that information. The next change is a reference on page 6 that references the National Center for State Courts poll. And in order to include that reference, we would need to make sure that that poll is included. Most of the other changes were included in the resumption of jury trial section that Judge Bridges has already discussed. On page 24, the last page of the task force report, co-chairs are recommending that the separate section for recommended statutory or rule changes and funding concerns be deleted from the report. Those are the changes that have been made, other than the sections of the report that have already been approved today. Any questions or discussion about any of those items?
Good afternoon, Judge Corpening. This is Elisa Chin-Gary once again. I recall Justice Beasley in a press conference noting that our legislators really had their hands on the purse strings, and she was asking their support in ensuring the courts had what they needed to operate during the pandemic. If we were to remove language that address funding, my thought or comment is whether or not that would diminish the opportunity to have legislative support.
Don't know the answer to that, Clerk Chin-Gary. I do know that the funding requests have already been submitted by AOC. And our report is to the Chief Justice for to address the concerns that she's asked us to open for discussion. Judge Bridges, thoughts about that?
Thank you, Judge Corpening. Frankly, I think we can look at this from both sides. An argument could be made that our expression of concern about funding could help support the request for funding. An argument also could be made that if we include a section echoing the requests that have already been made by the Administrative Office of the Courts and by efforts on behalf of the Chief Justice to obtain sufficient funding for the courts from the legislature, that we might be acting simply as a rubber stamp for the Chief Justice in trying to carry out things that she requests. Obviously, we were all asked by the Chief Justice to serve on this task force So that's a tough question. It could cut either way. It could be beneficial. Potentially, it could actually be damaging to the efforts of the court system to seek funding, depending on how it's viewed.
This is Jay Corpany again. One of the concerns that Judge Bridges and I've had about this issue is that as a task force, we have not discussed any of this during our meetings. And our challenge would be then what to say and whether what we say will help or not. Given the fact that the request for funding has already been made, together with the fact that as a task force, we have not discussed specific funding issues. That was our concern in having a separate standalone section. Other concerns, other questions, other discussion?
I would just make a comment on that. I think sort of a corollary of what you're saying is we've put a lot of recommendations down here. And in particular, the ones that are longer term recommendations are going to require fairly specific resources to effect. And we haven't had the relationship with the technical folks in the AOC to actually look at each of these recommendations and get serious about what it's going to cost. I'd hate to see us put something in here and it be used to limit what's provided. I think I'm pretty well convinced that this is going to be a longer term problem and for the courts, and it's going to take some creative use of technology, and I just don't think we're in any position to say what that is.
Thank you, Mr. Harrison. This is Jay Corpany again. Other discussion from the members of the task force, other questions?
Judge Corpening, this is Danielle. I know I'm not a member, but could I speak for just a couple minutes?
Please.
I just wanted, it's not on the agenda, and I should have thought to ask you all to include this, but I thought it would help for this discussion to give a little more clarity on what the next steps are. My understanding from a conversation with Anna Stearns in Chief Justice Beasley's office is that what the chief would like to do is receive our second report and then have AOC, i.e. me, create a final report that kind of pulls out the recommendations that are directed at local judicial officials and put them in a specific field guidance document that will be circulated widely to the field. So it's my understanding that these two reports, while they will be posted on our website, and the first one is indeed already posted on our website, will really be more internal to the chief, and that the final outward-facing document will be in the form of field guidance that is culled from these documents, if that makes sense. So I'm not sure the intended audience for this report is legislators, I guess is my long way of saying that.
Thank you, Danielle. This is Jay Corpening again. Any other discussion or questions?
This is Elisa Chingary. I'd just like to say thank you for that feedback.
Thank you, Clerk Chingary. This is Jay Corpening again. Danielle, that certainly is helpful feedback. Any other discussion or questions? All right, then I'll ask if someone is willing to make a motion to approve our final report with the updates that I have included in my remarks at the start of this section on the agenda.
This is Judge Benson. I make a motion that we approve the final report subject to the remarks that were made by Jay Corpening.
Motion's been made by Judge Benson. Is there a second?
This is Elisa Chin Gary. I second the motion.
Thank you, Clerk Chingary. This is Jay Corpening again. Any discussion on the motion? Hearing none, I'll ask Emily for a roll call vote on approval of our final report.
Judge Bridges,
I vote yes.
Judge Corpening,
I vote yes.
Judge Sermon,
Yes.
Judge Vincent,
Yes.
District Attorney West,
Yes.
District Attorney Evans,
Yes.
Clerk Chingary,
I vote yes.
Kinsley Craig. Yes. Kelly Myers,
Yes.
Jennifer Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison,
Yes.
and Mr. Keister.
Yes.
That is everyone.
Thank you, Emily, for the roll call. The motion is approved unanimously. Could I just say, wow? The co-chairs are going to exercise a point of personal privilege to, at this point in the meeting, to thank you. Judge Bridges, I'll go first and save the best for last, if that's okay with you.
Yes, sir.
All of you have come together on very short notice and worked tirelessly to offer this guidance to the Chief Justice that I know that she will value and that she will find useful. All of you were busy anyway, and then you jumped in and every week spent time working on this, sometimes spent time every day working on this, sometimes in the evening as well. And so I'm grateful to you for your willingness to work. Certainly, all the work that each of you have done, particularly those who have chaired our three committees. We could not have done this without you, and you certainly have made our job as co-chairs much easier than it otherwise would have been, and we're grateful to you for that. And I think people of the state of North Carolina are grateful to you as well. So thank you for your service on this task force. We may get called back later, and if we do, then we'll jump back in. But at this point, I'd just like to say thank you for your service. And Judge Bridges, I'll turn it over to you.
Thank you, Judge Corpening. As Judge Corpening just said, this is Don Bridges. And at this point, we do not know whether or not our work will be complete with the submission of this second report. If the Chief Justice calls upon us again to provide further service, I look forward to working further with each and every one of you. If not, I think I would be remiss in not taking an opportunity to thank each one of you for your service on this task force. And if you will permit me the opportunity, I want to take just a few minutes to go through and mention a number of folks by name. In particular, we have a number of staff members who have worked largely behind the scenes throughout the efforts of this task force. Those of us who are members on the task force, we wind up announcing our names whenever we make comments or ask questions or vote on matters. But largely our staff members go unrecognized, and yet our work would not have been possible without their efforts. They include, among others, from AOC, Emily Mehta, Sean Cowan, Tina Krasner, Matt Osborne, Nikki Brinkley, Melissa Jackson, Kim Rutledge, Faith Taylor, Anthony Whitmore, Christine Villaverde, Mildred Spearman, Andrew Simpson, and Sharon Gladwell. We also have had support from the School of Government, from Jim Drennan, Cheryl Howell, and Ann Anderson. We have been provided with a public health expert, that is Dr. Erica Wilson, and we're certainly grateful for her work. Director McKinley Wooten has served as a point of contact for this group, as has Anna Stearns, Chief of Staff to Chief Justice Beasley. I would like to also specifically mention how much I have enjoyed getting to know and working with Judge Jay Corpening. I appreciate Judge Corpening's leadership on this committee, his vision, and his tireless efforts in serving as co-chair. As he has mentioned, I also appreciate greatly the works of each of our working groups, and especially the chairs of those working groups, including Kelly Myers with the Best Safety Practices Work Group, Judge Chuck Henry on the Innovation and Technology Work Group, and Jim Drennan on our Virus Fatigue Work Group. And I specifically left one name that I wanted to mention specifically, and that's Danielle Carmen, another member of our support staff. Danielle has provided tireless efforts to this group. She has spoken with me by telephone at all hours of the day and night throughout our efforts, and I really appreciate the effort she has made in literally typing up all of our reports, helping coordinate our production minutes, and we certainly could not have produced this work product without her efforts. I want to say just one thing in closing, and this is the final note I'd like for everyone to consider. The members of this task force represent diverse backgrounds and diverse interests. Because of those varying viewpoints, the points from which all of us come, we have not always agreed on the issues that have been placed before this task force. Nonetheless, each and every member of this task force has conducted himself and herself, in my opinion, with complete professionalism and respect for each other and for these differing points of view. As we all know, the human body becomes stronger through exercise, something that often produces pain. In the same manner, policy issues are sometimes painful to confront and solve, but we likewise become stronger through that form of exercise. Our differing points of view may have made our task somewhat more difficult, but I believe that the strength of this group, just like the strength of our nation, flows from our interaction and our exchange of those differing points of view. It's been my privilege and honor to serve with each and every one of you as a member of this task force, and I thank each and every one of you for your dedicated work, your dedicated efforts, and your diligent service on behalf of the courts of our state. Thank you very much.
Thank you, Judge Bridges. It's been a privilege to serve with you as a co-chair. And I'll add my final thanks to Danielle Carmen. The three of us, Judge Bridges and Danielle and I, have communicated incessantly. I can't begin to count the number of emails or texts or phone calls, and Danielle, for your support. We are truly grateful. And it may surprise some of you, but Judge Bridges and I had not met before this process. But now we're daily phone buddies almost. So I'm thrilled that has brought us together to get to know each other. Thank you again for your service on the Chief Justice's task force. With that, our meeting is adjourned. Thank you, everyone, again for your service.
All right,
Thank you. Thanks.
Everybody.
Thank you, everybody.
And Jay,
See you, Waylon. Thank you.
you men have gone well above and beyond being a judge. I can assure you, we never anticipated this work.
No, never anticipated this.
No. So good job. We'll talk later. Thank you.
Thank you, Waylon. Take care, everybody.
Bye.